of Dysautonomia International, and tonight we have the privilege of having a wonderful guest for you all to hear from. So I will go ahead and get introduced, and thank you all for joining this webinar on long-term disability. Andrew November is a shareholder with Liner Legal LLC, where he dedicates his practice to representing individuals with disabilities. Andrew began representing individuals denied disability benefits by the Social Security Administration and has since represented over 3,000 clients at the initial application stage before administrative law judges in the United States District Court and the United States Court of Appeals. In 2014, Andrew expanded his practice to include long-term disability claims. In addition, Andrew represents deaf individuals who have been discriminated against and regularly brings lawsuits against people and institutions that deny equal access under the ADA. Andrew is a Cleveland Metropolitan Bar Association member and founded the Social Security Disability Section in 2017. Since 2015, he has served on the Deafness Advocacy Committee for the Cleveland Hearing and Speech Center. Andrew earned his BS degree from University of Cincinnati and his JD degree from Case Western Reserve University in Cleveland, Ohio. Welcome, Andrew, and we're so lucky to have you here tonight.
Well, thank you so much for having me, Zoe, as well as the entire community that's here today. I see we have at least 56 participants, so that's a great number. So I appreciate everyone coming out late on a weekday night. As you heard from my bio, everything I've done has been in disability litigation. I see questions coming in already, so I'm just going to ignore those for now because I think we're going to deal with them at the end. I was just making sure nobody was talking about tech issues. So no tech issues. Everyone can see me and can see my presentation. So back at it. So yeah, everything I've done since graduating law school in 2009 has been related to disability litigation. And it's interesting I'm presenting to you guys today because just last week, I settled a case in federal court, United States District Court, and my client's primary impairment was dysautonomia. And it was a very complex case because as I don't have to tell this audience, dysautonomia and the limitations associated with the condition often don't lend itself to measurable objective findings. That's my favorite phrase, and I'll probably say it again tonight. Measurable objective findings. And what I mean by that is in some medical records, it can be very obvious what someone's restrictions and limitations are. Restrictions and limitations, that's a phrase that's used by insurance companies. So if you've heard R&Ls or heard those words, you're probably familiar with disability litigation. Restrictions and limitations are essentially what prevent someone from doing a job. But back to my starting point, and that was measurable objective findings. So, for instance, if an individual has back pain and alleges they're unable to sit, that might be an easier case to see in a medical record. For instance, an MRI might show that they have a disc protrusion, which touches a nerve, and the nerve pain radiates to their leg, and when they're bending at their waist, it's going to cause more pressure on the nerve, which would explain their allegation of being unable to sit. So that would be a case that would lend itself to measurable objective findings, whereas a case when you're dealing with dysautonomia or other conditions like that, where the allegations might be pain, neuropathy, weakness, or other type of sensory problems, those don't lend themselves to measurable objective findings. So those are often the type of cases that I litigate on a regular basis. So that's kind of a unique background for this presentation, that I was just really in the throes of a dysautonomia case just last week. So my theme today, and to every presentation in general, is you don't know what you don't know. I think that's a good phrase to use in every aspect of life, but particularly as an attorney, I use that phrase all the time. It's something that prevents me from stepping in landmines, jumping into a case that I might not be aware. And what it means for you guys today is that maybe you heard of short-term disability, maybe you heard of long-term disability, but most people haven't. And the crazy thing is if you work for a professional job, you probably have it, almost certainly. Even many other jobs that we might not consider white collar, as that term is used, offer long-term and short-term disability benefits. I see Amazon expanding like crazy all over the country, and almost every employee at Amazon is eligible for short-term and long-term disability benefits. So that, those are clients that typically didn't have this type of coverage in the past. So it's interesting that this benefit is spreading. Most people probably learn about short-term and long-term coverage in their first day at work. Maybe they're going through orientation, but it's probably the last thing that you're thinking about when you meet with HR, you're signing your paperwork, getting your taxes going. You're probably not even thinking about it. And so oftentimes people don't learn about it until they're denied. And I hope that's not when they're learning about it, or they're learning about it when they've developed an illness. Maybe they had an accident, or maybe they're dealing with an aggravation of a pre-existing condition, and suddenly they can't work, and they got their last check 2 weeks ago, and they might not have a future paycheck. So people find me, or people find these insurance companies when it's often too late. So, this presentation, 75 people here today. Some of you probably have questions that you want answered, and I can see them rolling in already. Some people probably, they're healthy, they have nothing to worry about. So just file this information away. And you might have seen the Social Security presentation that my partner Michael Leiner gave, and kind of the same idea here, that I just want to plant this in your mind so you have the resources to help yourself, help a friend, help a loved one, help a stranger that you're connected with through this great group, shall they find themselves unable to work and battling an insurance company. So a little bit about me, I've kind of alluded it. I've been practicing since 2009. This is all I've ever done. I started doing Social Security disability claims. I did that for 7 years exclusively, until a family member went out on short-term disability. And that was my first exposure to this case. My family member needed help with her paperwork. And I said, it seems like what I'm doing with Social Security. And as they say, the rest is history. So I've dedicated my practice now to doing short-term and long-term, and I still do Social Security cases because I've been doing it for so long and I'm really good at it. But I really like the challenge, and I really like fighting with insurance companies, because insurance companies don't make money paying cases. So I'm going to do everything I can to make them pay my clients. I don't do so much service-connected veteran claims anymore for a lot of reasons. I did enjoy it when I was doing those cases. Service-connected veteran disability claims, you can kind of think about it like workers' comp for men and women in the service. So they're not eligible for typical workers' comp, but if they get injured in the service or have an aggravation of a condition, they can get benefits there. All right, so let's get into this. So, just generally speaking, short-term and long-term disability or income replacement insurance, that's a thought behind it. And it kind of goes into my opening remarks that this is for people who don't think they're going to be able to work to get their next paycheck. The vast majority of my clients are what I call group, or not what I call, what is called group insurance clients. And that means they got their insurance through membership in a group. So what does it mean, a group? Well, Leiner Legal, my law firm, we are a group. We're a group of 20 plus individuals who has a policy with a company named Guardian Insurance. Guardian Insurance sells that to our law firm, and our law firm pays a premium for the whole group. So what that means is there's no individualized assessment of my employees. They don't have to submit to an examination. They don't have to answer any health questions or disclose any of their background, which makes it risky for the insurance company because they don't know who they're insuring. although they build into their policies limitations and exclusions, such as pre-existing condition, which I'll talk about in depth in a moment. So that's how they prevent losing a lot of money on these groups. But don't feel bad for the insurance companies. They're doing fine because these premiums aren't cheap, and we know they're making a lot of money. How do you pay for this? Well, oftentimes it's paid through pre-tax dollars, which would just be an automatic deduction from your check. This is really important to know. Take a look at your pay stub when you leave here tonight, because this will have an implication on whether you're taxed or not. So if you're paying your premiums with pre-tax dollars, then when you do receive your short or long-term disability benefits, that is income that would be taxable at the end of the year. If you're an individual who decided to pay with your net earnings, then it would be after tax. And those are my favorite, because when I settle a case for those clients, I just say, this is your money. Do what you want with it. Don't worry about paying taxes. Elimination period. An elimination period in plain English should be called a waiting period. Every disability policy out there has some type of waiting period. Even Social Security does. Social Security has a 5-month waiting period. So if you become disabled today, December 8th, the 5-month waiting period would start January, February, March, April, May. June 1st, 2023 would be your first day that you would receive a check. So that's pretty painful right there. As far as short-term and long-term go, the short-term waiting period is typically, I'm going to stop right here and say one thing I normally say right at the beginning is it depends. A lot of things I say today are going to be it depends. If you ask me a question about Social Security, I can answer that with my eyes closed, not only because I've been doing this for so long, but because the same rules and regulations that apply to you apply to you. Whereas a short-term and long-term disability policy is a creature of a contract. That's a phrase that lawyers like to say. And what that means is everything that's going to govern your dispute with the insurance company or your coverage, if you want to look at it a little more optimistically, is going to be contained in the 4 corners of the document. So I bring that up right now because I realized when I was talking about elimination waiting periods, I would have to say that it depends on your policy, but a few things hold true. I've been doing this long enough that I see some things that repeat over and over. So most short-term waiting periods are about 1 week to 2 weeks, 7 to 14 days. Long-term disability, you're going to see a 6-month waiting period, so 180 days. That's almost standard. So it's in order, it's if you have the ability to plan around the waiting period, of course, do that. But most people don't have that luxury. So waiting for your disability payments to start can be quite painful. The last bullet point, percentage of pre-disability earnings. So you might say to yourself right now, or maybe it's in our question box, which I'm trying not to look at, so not to distract myself any further, is how much will I get? Well, it's based on your contract, but most contracts I see, again, there are some things that repeat, will pay 60% of your pre-disability earnings. So it's a big chop right there. And again, litigation often follows with what do they mean by pre-disability earnings. I just got a lady approved and they sent her a check and I looked at it, I'm like, that doesn't seem right. And I realized they only looked at her her base earnings, but she was a saleswoman and she got commission. So I took a look at the policy, and within those 4 corners, it said that they had to look at the average commissions over the 12 months that preceded her disability. And I found another $10,000 or so for her. So that was a big win. And again, you don't know what you don't know learning moment. So you really got to read that policy and see how they define things like pre-disability earnings. So here's some facts and figures on short-term disability. We talked a little bit about this. Again, 7 to 14 day elimination period. I did put a bullet point in there that says it can pay 100% of pre-disability earnings, I do see quite a lot of policies, short-term policies, that will actually pay 100% for short-term, but then almost all of them drop down to that 60% level when it gets to the long-term claim. Now, one of the biggest hassles as a lawyer, and I can't imagine doing this as a client without a lawyer, is transitioning from short-term to long-term. And I just realized my presentation says LTD versus LTD. I don't know what I was trying to say there, but what I'm trying to say to you right now is that, as we know, short-term claims only last for 3 to 6 months based on what the contract provides. So you're thinking, well, how does long-term start? Most companies, if it's very clear that you're not going to return to work in 6 months, will initiate a rollover process. But there are companies out there, one that I'm seeing quite a bit lately is Cigna, but Cigna is now going by a name called New York Life Group Benefit Solutions. You might know them better as Life Insurance Company of North America. I probably need a corporate lawyer with me right now to explain how corporation law works, because it's a very challenging aspect of our practice, is trying to find who's the right person to sue, because these companies are often subsidiaries of bigger companies. But for instance, dealing with New York Life, Cigna, whatever you want to call them, they actually require a complete separate application. So I have at least 5 clients right now who were denied short-term, hired me to represent them on their short-term case, and then it takes some time to do that. So I've got to simultaneously help them fill out their long-term disability application. So that's something to watch out for. How is your policy going to treat that? And if you don't know that, then you're probably going to have a lapse in your benefits when you get to the maximum duration of your short-term policy and you attempt to transition over to long-term. This is an example, and let me stop here. So the next few slides are going to be kind of those it depends slides. A lot of things in my presentation, I think this is a really cool way of doing things that I just copied and pasted from actual documents. So you can probably tell I didn't type out that language. That's a PDF image from a prudential denial. And this was a paragraph that I found in a prudential short-term denial. And it says, if you choose to appeal our decision, your long-term disability claim will be considered filing on the later of 2 dates. 1, at the end of the elimination period, or 2, the case is approved. So this one automatically has information telling the individual when their long-term disability application will be filed. Now, often it doesn't. This is the language I was using up until a few months ago, and I've actually updated the language. So basically, I would put this in a footnote, and I would say that this is an application for long-term disability benefits. I still think this is a fine way of doing things, but what I've been doing now is kind of acting like a surgeon, going into the policy, finding exactly the terms of when and how someone must file for long-term, and putting it more specifically in there. For instance, if someone hired me on short-term to file the appeal, and then here we are on December 8th, I would say, well, it seems like we are already in the long-term disability period, where, we've invaded that period of time. So here's evidence from that period of time that supports my client is disabled during that period. The reason why I do that is twofold. One, because I obviously want to maximize my client's benefits, but 2, I'm always thinking ahead, because these insurance companies are going to fight. And if I sue them and I didn't do that, then arguably they could file a motion to dismiss for the long-term portion, saying there is no long-term claim. But I did some legal research, and there's some courts that say if you proffer evidence during the period of time that you would be eligible for long-term, then the court would have jurisdiction on that. So that's what I try to do, is to try to address all the periods. For instance, I noticed that just today, a brand new client, her long-term period is going to start next Friday. So we're filling out an application this week. I think my paralegal started it today for her, and she's going to just kind of get the jump on it. The vast majority of my cases up until this year were long-term disability cases. I hardly ever got hired on a short-term denial. I don't know why that is. I suspect that maybe, short-term cases are approved pretty easily because they're short-term. Maybe they're just not a big liability. But every single one of my short-term denials are all from New York Life Group Benefit Solutions. So I'm not insinuating, but it's kind of interesting that since May of 2022, I've got a ton of short-term denials, which again is causing a big headache, but that's what we're there for. So the vast majority of people would come in with long-term disability denial. So again, we talked about group a bit. I didn't bring up individual because I can count on one hand how many individual policies are. So what's an individual policy? Well, that's me picking up my phone and saying, I want disability insurance, and going out and buying a policy. If you have the ability to do that, I recommend doing it, because you are vetted before you get the insurance, and the insurance word for vetting would be called underwriting, which means you'd probably have to go through a medical examination, and they're going to do their risk calculations, and those cases are often approved. So the reasons why I don't see individual policies in my office is because people get approved for them. The only cases I've seen in my office were when the insurance company accused my clients of lying on their application, and maybe not even intentionally lying, but omitting something from their application. And the two times that I saw that, the insurance company was right. So it's the cover-up's always worse than the crime. So don't omit anything from your policies or your policy application. Again, the standard is 60%. I've seen as low as 40%, and I've seen even higher, close to 70, but almost universally it's 60%. The elimination period is usually the length of the maximum benefit period for short term, which is often 6 months, 26 weeks. I don't often see 12-week policies, but they're there. Another question I get almost immediately from my clients is, well, how long can I get these benefits? Almost always it's to your Social Security normal retirement age. For most people, that's going to be 67. Some of our older members here tonight might be closer to 66. I doubt anybody at 65. So that's a great policy that would pay to your full retirement age. Some policies just straight up end at 65, and other have contractual limitations, which we'll talk about in a later slide. This is a slide from a presentation I gave to some insurance salespeople, and I wrote this slide because I said this is what you should tell people as a selling point of why you should have individual disability, not just group. One of the best things about private disability, let me just check to see what my next slide, okay, yeah. So I wanted to make sure my next slide was going to back up what I was going to say right now, is they often have what's called a true own occupation test. So take me as a lawyer. If you look at the Dictionary of Occupational Titles, it's a book that's published by the Department of Labor, or was published many, many years ago by the Department of Labor. There's about 10,000 occupations in it, and it has several lawyers. All those lawyers are rated as having a strength level of sedentary. And what does sedentary mean? Sedentary means that you're not expected to stand or walk for more than 2 hours in an 8-hour workday, or lift and carry more than 10 pounds. My job, at least before COVID, did not look like that. I was often never in the same place more than 2 days in a row. I litigated all over the country, certainly all over Ohio on a regular basis. I did a lot of standing and walking and arguing, and sometimes I'm arguing on my feet. So as a trial attorney, my occupation should probably be classified as light. Light means that standing and walking is somewhere more than 2 hours, but closer to 6 hours. I would say I'd stand and walk for 4 hours in an 8-hour workday. So for me, when I bought my policy, I insisted on having a true own occupation. So when I go, knock on wood, to claim disability, it will look at how I performed my job, not like just some contract attorney or some insurance attorney. I see Zoe popping up. Not sure if that means we have an issue.
Hi, Andrew. Just a quick clarification question I think some people are having before you continue on. If you can differentiate between the difference between long-term disability and short-term disability, and then also the difference between SSI and SSDI, I think would address some of the questions that are coming in.
Sure. So short-term disability and long-term disability. Short-term, again, they're both insurance contracts, and short-term disability is typically what's going to cover you for 3 to 6 months. I've never seen a short-term policy longer than 6 months in my life. Long-term disability is going to cover you after 3 to 6 months, and typically until you're age 65, your full retirement age, or excuse me, some other contractual limitation applies. Now, SSI and SSD is not part of this presentation, but I'm happy to answer it. And SSD and SSI are both forms of disability that the Social Security Administration provides. SSD stands for Social Security Disability Insurance. And you hear me going SSD, SSDI, it's the same thing. SSD is based on your work history. So when you work, you pay taxes and you become insured for disability benefits. SSI, on the other hand, is based on financial need. So it looks at your financial resources. And for a single individual, you can't have more than $2,000 in the bank account. There's a lot to say on this topic. If I continue to talk too much more, I'm going to run out of time to talk about a lot more of our LTD and STD presentation. I don't know if the Dysautonomia group can make those past presentations available. I think my partner, Michael, spent an hour talking about SSI and SSD. I'm happy to come back and talk again. I have so much more to say than that cursory overview, but I will absolutely run out of time as I see it's 7:30 already. Again, Zoe, feel free to chime in if my clarification wasn't enough. So the next few slides, we're going to actually focus on what I've seen in many policies. This is actually, now that I think about it, from my policy, Berkshire Life. Again, their trade name is Guardian, but what that indicates to me is that the underwriting organization, the company who's going to pay the benefits, is actually called Berkshire Life Insurance Company of America. As you'll notice in the first highlight, I'm not sure if you can see my mouse, I'm circling it. It says your occupation. And whenever you see capital letters in a disability policy, that means that it's defined later. So look at all the capital letters in the first paragraph: total disability, totally disabled, injury, sickness, your occupation. Those are all capitalized. So that means they all have definitions. So I told you this was a true ONOC, and it says later here, this is actually from another page. This is the actual definition of your occupation, and it's what you were doing in the 12 months prior to the time you became disabled. So even though I think this is a great advantageous policy, it does look at what you were doing in 12 months prior. So arguably an individual who changes their job during some course could face an issue. So if you have a job that's of one exertion level and then you change it, and 12 months later, or within 12 months later, you become disabled, they're going to look at that occupation. So that would be a risk for this policyholder. Now let's get to group policies. I'm going to give you an example of a few group policies. So what does it mean to be disabled under a group policy? Well, almost, again, I'll use the word it depends. Almost all LTD policies, and this will include short-term, and it'll make sense here in a second, have a 2-year test and a test and that changes after the first 2 years. So what I mean by that, so for the first 2 years, almost all LTD policies will find that you're disabled if you can't do your own occupation, and we'll explain what that means here in a second. And then after the first 2 years and up until full retirement age or age 65, you'll have to show that you can't do any occupation. And before this year, 2022, almost all the new clients I had were individuals who were transitioning to the any occupation definition of disability. And that's when they would get denied, and you'll see why in a second. So this is a very classic policy. It says a few things here for the, again, highlighted for the first 24 months. So we know it's the first 2 years that you're unable to do your own occupation. And I put this one in there because it's got a little fun twist in there, or other appropriate work assigned by the company. So that's not a fun provision at all, actually, because this is going to give an incentive for the insurance company to convince the company to find other work for the individual. This policy also requires that you at least are earning less than 80% of what you normally were getting paid. That's almost always a given truth. I have very few people that are still working. When they come to me, it's usually an all or nothing bet. Here's another example. This is probably one of the more common ones, and I'll explain why in a second. So this test says that you are unable to do the material duties of his or her regular occupation. And it's interesting because it doesn't define material duties. That's something a lawyer would like to see, because that gives us something to play around with. But the regular occupation is capitalized, so we know there's a definition, and I've included it on this one slide. This is problematic for a lot of reasons, because what it says, this is actually like the converse of a true ONOC. I mean, it's like anything but a true ONOC, because it says it looks at how the occupation as it is normally performed in the general labor market of the national economy. So I had a client who was a respiratory therapist. Her job actually required her to move patients around. So that's lifting and carrying, pushing and pulling 100+ pounds. Respiratory therapist is not categorized that way in the DOT, again, the Dictionary of Occupational Titles. The DOT says it's much lighter. Lawyer, I told you guys that I am up and around moving. Well, lawyer is sedentary. I had a client who worked for a big company here in Northeast Ohio, and she was, I guess the insurance company wanted to call her a secretary. She was not. She was an executive assistant. And so that means that she was running around. The campus had 4 buildings. She was traveling with her boss. And they said, oh, we see your medical records do support you can't do anything more than sedentary work, but a secretary is sedentary work. So you can do your own work. And she was denied under that own occupation. So I actually had to hire a vocational expert to say that's not her job. That was not her job. And we did prevail on that case. Here is another definition that actually adds a layer. And here they're not using capitals. This is an example where they're using italicized letters. So in this policy, if this was your policy, if you saw italicized letters, you would know those were later defined. This one actually required the individual to be under regular care of a doctor, and it defines that. That was a big problem for a few of my clients, because sometimes your condition doesn't require ongoing treatment because there's only so much that a person can do. So we've often get in fights, well, what does regular care mean? All right. So this is where the fights almost always happen. Most people win on their own occupation because, truth be told, if you could do your own occupation, you probably would be working. Here, people get denied. So let's take the easiest example in the world. If you're a construction work laborer, lifting and carrying 100 pounds, throwing around bricks, and you hurt your back, Well, it's probably fairly obvious that you can't do your own occupation. But after 2 years, are you going to be able to show that you can't do sedentary work? This is a very aggressive policy because it says that you're not disabled if you can do any gainful occupation. So not a good policy right here. Here's one that gets a little bit better, and let me show you why. So again, this one says that you have to show that you're unable to perform the material duties of any occupation, but you also have to earn a certain amount of money. So I like to call this, and this is point number 2, the income threshold test. And what I mean by that is that they can't just, okay, say you're a big time executive at a pharmaceutical company. They can't just say, oh, well, you can go be an assembler of small products earning minimum wage. They have to show that you can earn at least 80% of what you were making before you went disabled. This adds a little dignity to the policy. And again, this is great for a lawyer to see because we work hand in hand with vocational experts and we do labor market surveys. And we say, oftentimes you just can't make that much money. So I love to see an earnings threshold test in every policy. They're pretty common. This I brought up because it's probably one of the most aggressive policies I've seen. This one was problematic for a couple reasons. One, and I wish I didn't have so many highlights on here, but if you look in that paragraph number 1, this requires the disability to be substantiated by significant objective findings, which are defined as signs which are noted on test of medical exams. Again, many conditions do not lend themselves to measurement. So lawyers often have to get involved. And what we do is we try to lay a foundation and we try to say that the symptoms and signs are reasonably consistent. Take Crohn's disease. What often keeps someone with Crohn's disease from working is nausea, vomiting, abdominal pain, or the need to use the restroom very frequently or urgently. Well, that's kind of hard to document in your medical records because most people don't call their employers after using the bathroom every single time. Not their employer, I'm sure you're not calling your employer, but you're not calling your doctor to say, I just used the bathroom for the 4th time today. So that can be a case, and dysautonomia certainly falls in that category too, where it can be hard to adequately show that someone's limitations are supported by objective evidence. Fibromyalgia is another big one that we fight a lot. Another thing that people need to watch out for, again, the theme of this is you don't know what you don't know, is deductible sources of income. One of the biggest surprises to people receiving group long-term disability is that their benefits are reduced by other income. Awful, awful, awful. So say, for instance, your disability contract with the Hartford says you get $2,000 a month. That's 60% of your pre-disability earnings. Well, that policy is going to require you to file for SSDI, Social Security Disability Insurance. And say, for instance, that your Social Security Disability Insurance is $1,000 a month. Okay, so Hartford's $2,000, Social Security is $1,000. What the Hartford is going to do based on the contract language is they're going to reduce what they give you by what you receive from Social Security. So in this example, you would get $1,000 from Hartford, $1,000 from Social Security, and that would equal the original $2,000 contract amount. This is an awful surprise to almost all of my clients. And what's even worse about it is it includes auxiliary benefits. Auxiliary benefits are the benefits that you're entitled, that your children are entitled to. It's litigated. It's a tough issue. It can make an entire presentation in of itself. There are things that are not deductible sources of income. And while I take a sip of my water, you can read over this. Probably the most common is a 401k. A lot of people will make contributions to their 401k, and then they might want to subtract some of the money from it to supplement what they're getting from long-term disability. and 401k is often not considered a deductible source of income. And here's some other types of investment planning that would also be excluded. So we're not going to spend a ton of time here because we're running out of time in general, and this is going to get into the weeds of disability litigation, but I want to introduce everyone to a law. And the law is called ERISA, which stands for the Employment Retirement Income Security Act of 1974. ERISA is a massive law that regulates employee benefits. So basically speaking, if you get benefits from your employer, it's going to almost always be regulated by ERISA. So what does that mean? Well, it preempts state law. So this law controls. What that means is these cases are universally litigated in federal court. Not such a bad thing right there. I prefer to be in federal court for a lot of reasons. But what is really unfortunate is that ERISA changes the way that every lawyer was taught on how to resolve a contract dispute. If there's any lawyers in the audience or anybody that's taken some law classes, you know that when a contract is ambiguous, it is held against the person who drafted it, is how it should be, right? Well, not on ERISA preempted cases. ERISA preempted cases often follow the discretionary authority rule. And what that means is if the disability contract has a discretionary clause in it, the discretionary clause might say something like, I, the Hartford, am able to determine how this contract will be interpreted. That means that a court is only going to overturn their decision if the claimant or the plaintiff, the disabled person, can show that the policy decision was arbitrary and capricious. So it sets up a very tough time to litigate these cases in court. Let's talk a little bit about timelines. And this is in the ERISA section because one good thing ERISA does is it provides some clarity. So if you file an initial application, they have 45 days to make a decision. However, the insurance company is entitled to 2 30-day extensions under ERISA, which means they have 105 days to make the determination. If the initial application determination is unfavorable, you have 180 days to appeal, or 6 months. Once you are denied, probably when you want to see your lawyer. I strongly advise you to not react. It's better to respond. That's a way to live. It's something I try to incorporate. I often fail at in my life all the time, but a lot of people reflexively just appeal. I'm going to get you, insurance company. Why is that a problem? Well, the insurance company is required under ERISA to address your appeal in 45 days. So if you get denied tonight and you shoot off an email, and a lot of people communicate with insurance companies through email, so it's very easy to do this and just say, I appeal. Well, they're going to start the appeal process and they might make a decision pretty quick. And then the case is going to be over. So I caution everyone to remember you have 180 days to appeal. Talk to a lawyer or at least request your claim file. Once an adverse decision has been issued, an adverse decision means a denial, you have a right to your claim file. So you can see every piece of paper in there, and they must give it to you within 30 days. So you have some leverage on the company with that. So when someone hires me, the very first thing I do is I request their claim file. And unless the issue is obvious, I don't do any work until I read the claim file. That's my process. So once I understand what we're appealing, I file my appeal, and the insurance company has 45 days. Now they can extend it up to 45 days. A lot of lawyers, including me, are being very bullish on those extensions, and we're really trying to change the law for the better to force the insurance companies to decide the case in 45 days and not to automatically allow them another 45-day extension. But again, that's a topic for a different day. As I noted, that these cases are exclusively filed in federal court. So I wanted to wrap up by some things that will often catch people off guard. And one is exclusions. These are the common exclusions that you see in every policy. Injuries secondary to a crime, not something to roll your eyes at and say, I'm not a criminal. Well, many motor vehicle accidents are criminal in nature. So I've had a lot of people excluded because their accident was cited as a criminal act, and therefore their injuries are secondary to a crime. Intentional acts, often suicide attempts. If you try to end your life and you cause yourself great injury, that might not be covered. Drug and alcohol abuse, that's what number 7 stands for, but the most common is a pre-existing condition. So we're going to go right into that. I see these all the time. So almost always the policy will say something like this. If your disability begins in the first year of your employment, the pre-existing condition limitation is going to be implicated. And what that almost always means is they're going to look at your medical records for the 3 months prior to the 3 months prior to the date your insurance took effect. So if you became an employee at Liner Legal December 8th today, and you went out on disability tomorrow, well, they're going to look at the 3 months prior to today to see if you received any medical treatment, consultation, care, services for your condition. And there's a lot of different policy language out there as far as what a pre-existing condition is. I litigate those cases all the time. Here's another example. I wanted to see what the difference was. So you can see the language is just a little bit different. Again, these both have 3 months. This one's very aggressive because it's looking at even if it was misdiagnosed. That would have really harmed one of my other clients. I had a client once that was complaining about pain in her leg for a year, went to the Cleveland Clinic, one of the best hospitals in the world. They couldn't figure it out. Well, eventually she was diagnosed with cancer, and they denied that as pre-existing condition. And I said, hey, the Cleveland Clinic doctors couldn't figure it out. It wasn't misdiagnosed. They followed the standard of care. But with this policy, and she might have had a harder time. Almost every group policy has a mental health limitation for 24 months. Simply speaking, if you have a condition that causes your disability and it's based on mental health, you can only get benefits for 2 years, even though your contract says you might be able to get benefits up until full retirement age. We litigate those cases often, and when we litigate them, we're trying to show that our clients are disabled but for their mental health. Here's a very common definition, and this means any disorder that's in the Diagnostic and Statistical Manual of Mental Disorders, the DSM, which is the book that all psychiatric practitioners use. And there's so many disorders in there. So it's very easy to find yourself limited by a mental health limitation. Self-reported symptoms. This is a big issue for a lot of people who are disabled because of fatigue or pain. Basically, any condition that you tell your physician that's not verifiable. Migraines, disorders fall under this. Post-COVID cases that are based on fatigue often fall under this. This is a big problem. I've litigated this in court for fibromyalgia, which is not self-reported and is verifiable according to every reputable rheumatologist I've spoken to. All right, so that is the end of my formal presentation, but I'm going to stop now because I see questions are piling up.
Sure. So I actually am going to go through and try to help us get through some of those questions. So thank you so much, Andrew, for all of that insightful information. I know we all on this call and who will have access to watch it later really do appreciate that.
Sure.
So the first question I have for you is, if you haven't worked for a few years but have significant work history, can you still qualify for short-term or long-term disability?
Most likely not, for a couple reasons. Usually policies require you to file within a certain time period. Oftentimes it's 30 days, and most generously I've seen 1 year, and that's because there's got to be some good reason. You also have to show that your disability began while you're what was called a covered participant, which means that you were employed at the time. My recollection is that if you try to show that you were disabled after you were a covered participant, you're not going to be covered. So most likely no. Unfortunately, the answer is no. So for that person, you would want to consider Social Security disability.
Great, thank you. The next question is, after you are found by insurer to be long-term disabled, how often does the insurer usually check on you, either from doctors or medical records after the first year and later?
Great question. It is not easy to be an individual receiving long-term disability. It varies, of course, but insurance companies are incredibly aggressive. I have horror story after horror story that involves surveillance. Surveillance is very common. Keep an eye out for that. These companies love to send out investigators. They often send them out for 3 10-hour days. So they're going to try to find you doing routine activities of daily living. If they're not surveilling you, they're going to be sending you what's called attending physician statements, which are forms that you need to take to your doctor. And I am sure they do that because they know it drives doctors' offices crazy. It pits the insured against their doctor. And they know that the doctor is going to get fed up and just say, I'm not going to do this. Or, maybe even start charging for the completion of the form. So I would expect, if you're only hearing from your insurance company once a year, consider yourself blessed. Most likely you're going to hear from them every couple months.
Great, thank you. The next question I have for you, lost my train of thought. Give me one quick second. The next quick question is, how does one go about finding a good attorney for either an STD or an LTD or SSDI, especially for complex, tricky cases that could include prior related litigation, poor attorney work, or complex health issues, or something similar?
Well, that's tough. I mean, I would approach it like you approach finding any professional. Read reviews. When you're reading reviews, see if they mention your issue. A lot of lawyers, unfortunately, advertise for this area, but they don't handle cases at all. If you want an attorney that's closer to you, and I understand that, you can message me. I'll find you a lawyer that's closer to you. But I would say, start by Googling, but then really read their website and see, is this a person that really does LTD, or is this someone that just says they're doing it? Read their reviews. If you read our reviews, you see our clients talk about LTD representation. So that's what you want to see. You want to try to find someone that's not dabbling. This is an incredibly difficult area of the law to be in for many reasons, as you probably saw in this presentation. So find someone that's actually doing it.
And following up on that note, for our individuals who are here with us tonight, if you've posted questions that pertain personal information or specific case examples, sadly, Andrew is not able to answer those questions, so I apologize for that, but we are so lucky to have Andrew here as well. The next question I have is, someone asked, is it possible to get retroactive benefits?
Yes. If you're getting retroactive benefits, that means something bad happened, because the benefits only accrue from the time you're found disabled. So if you go out of work today, December 8th, and there's a 2-week short-term waiting period, there's really nothing retroactive. So if you're getting retroactive benefits, that means something happened along the way for those to start accruing. So yeah, if you get denied and you have to litigate it, there's going to be a big chunk of retroactive, but it's not going to be able to predate your date of disability. Because remember, when we looked at that short-term test, is you often have to show, or not your short-term, the ONOC test, you have to show that you're not earning, say, 80% of what you were earning. So if you're working, obviously you're earning that full amount. So retroactive benefits in this world means something bad happened.
Great, thank you. I have 3 more questions for you. The next question, is there a benefit to having both the employer-sponsored LTD and a private LTD? Do they pay concurrently?
Yes, but you'd want to check both policies to make sure that there's no offset. Most group policies are not going to be offset by an individual policy, and likewise, an individual policy won't be offset by what you get from a group. But again, it depends on the policy language. So check, ask your agent. And yes, if you have the means and the ability to have it, absolutely, because everything we've talked about today has been the doom and gloom of dealing with group insurance policies, which are only going to pay probably 60%. So if you want to keep your standard of living, your pre-disability standard of living, you're going to want an individual policy to supplement it. And again, I told you I can count on one hand after all these years. Look how gray I am. How many people with individual policies have hired me to litigate them? It just doesn't happen. They just don't deny. Wood, they just don't deny those cases. I can't believe I just didn't make my dogs bark by stupidly knocking on wood, but I guess they're pretty tired now.
Great. The next question is, do all LTD policies have that clause that within 2 years you can do any job, or only some?
I've never, the most generous policy I ever saw was an Our House Furniture employee who had a 5-year own occupation period. So for the first 5 years, he was disabled if he couldn't do his own occupation, and then it shifted to ENEOC. So that was a really good policy. Must have cost the employer an arm and a leg to do that one. But almost every policy, first 24 months is ONOC, then after the first 24 months, it's ENEOC, and the ENEOC definition carries through until the maximum benefit period, which again is age 65 or full retirement age.
The last question this evening is actually having to do with the ERISA case information that you brought up. And the question is, if someone has won a case like that, does the Social Security disability process usually go through on the first try with legal assistance?
Can you repeat that question one more time?
Sure. If someone has won an ERISA case, does the Social Security disability process usually go through on the first try with legal assistance?
There's no connection. Strictly speaking, Social Security does not have to give any deference to other agencies' findings, especially a private insurance company. On the other hand, this is you didn't ask this, but I'm going to use this to tell you guys something really interesting. Under ERISA, especially the newer regulations, the insurance company is actually required to articulate the weight that they gave to your Social Security decision. So it is really important that you hire the right attorney to handle your Social Security case if you have a long-term case. And I know we're getting long on time, but this is a really important point. So if anybody's familiar with Social Security, you'll know that if you're over the age of 50, you can win your disability case if you're limited to seated work or sedentary work. Okay, it's a really easy way to win a case. Well, if you're in your ENEOC stage and you can do sedentary work, you might win your Social Security case, but you might lose your LTD case. So when people hire me to handle both their long-term and Social Security case, I have to reach out to judges, and I have no problem doing this. I've got a lot of goodwill over the years with the judges I deal with, and I'll say, look, Your Honor, I know you can pay this case really easy by putting my client at sedentary, but I'd like you to consider these other limitations. And these are limitations that are supported by the record, so we can use that win in court. So, if someone just wins their case with a sedentary finding in Social Security, that decision might be worthless.
Thank you so much, Andrew, for this great presentation. And thank you to everyone who joined us tonight.
Thank you.